forgot I did that. You are?
Steve DelBianco.
Okay, great. Steve DelBianco.
Thank you, Madam Chair. Steve DelBianco, I'm Executive Director of NetChoice, a trade association representing the leading e-commerce and online companies, including AOL, eBay, Facebook, Google, and Yahoo. And we began almost 3 years ago participating in the Uniform Law Commission, which is I guess it's the big business panel of the Trust and Estates Bar, as they were designing a bill that they admitted had a single objective. Their bill was to make their jobs easier as they went in to unwind an estate. And I understand that objective. And they were kind enough to invite those of us from industry to participate in the crafting of that law. And we explained from the beginning that we have obligations and liabilities under the Electronic Communication Privacy Act. Senator, you mentioned the federal law earlier. And our terms of service commitments to our users. Now, the estate attorneys at the Uniform Law Commission, they gave us a voice. We had no vote. And we failed to reach any compromise at all. And that's when the Uniform Law Commission published their standard bill. And it's a dramatic overreach in 5 ways. First, it reaches all fiduciaries, not just the estate attorneys, including reps for people that are still alive. It reaches all contents of electronic communication, including voice messages and photos and things that are not necessary to take care of the financial matters of an estate.
Madam Chair, can I ask a question? Just so I understand, what is the objection to someone who has dementia and has something where they don't have their faculties, or a minor who needs a fiduciary? Because you made the distinction of someone still alive, like me. I have my faculties. What is the allegedly, what is the objection to a fiduciary for someone who is incapacitated? That's what I don't understand.
Madam Chair? Yeah, thank you. The key is consent. We have federal law. And from the outset, those of us in industry have tried very patiently to explain that federal law controls that we cannot reveal the contents of communications without the consent of the sender or the recipient. So consent is the key. And if there are manners of legal process by which that custodian for that incapacitated person or that trustee can be able to show that they have consent of a living person,
so let me
satisfy that.
Let me interrupt you. Are you saying that that this law that she's proposing violates federal law?
Madam Chair, absolutely does. It forces us to pretend as if consent was given by a living person before they died, because the person who died is gone and cannot give the consent. My colleagues from AOL, some from Yahoo and Facebook will come up in a moment, Senator, and explain the exact conflict in federal law because you cannot deem consent, and they'll be able to cite cases on this. So there's no notion of big business trying to mine the data. All you're trying to do is mind the law. We cannot turn over the contents of communication without consent, or we are sued, and it happens all the time. We're not allowed to do so. So this bill is a significant overreach. It causes us to disregard our terms of service and our express choices that our users made.
But your terms of service are whatever you make them,
and whatever
no one reads, that you say accept. So let's not worry about the terms of service. You could change them tomorrow. What I'm trying to figure out is what you say is a conflict between the federal law and the state law, and that's a pretty serious allegation. Absolutely. You're saying that an attorney, Senator Uckel, who does this for a living, has drafted a bill and got behind a bill that violates federal law. So I would certainly want to hear a little more about that.
Would be happy to, Madam Chair. The bill requires us to pretend as if Florida state law can deem consent that is not recognized at all in the federal law. And my colleagues will cite the court cases that are on point to that. So the statute itself, on the face of it, Senator, doesn't conflict with law, but it pretends that the state can dictate what satisfies a federal law in cases where the court has said it doesn't work. So you wanted to disregard, Senator, terms of service, but let's be a little more explicit then. In Yahoo, Facebook, and Google, I can designate an alternate person. As the sponsor indicated in Facebook, I designated a legacy contact, my son, and he's the only one who has consent to wind down my Facebook account when I die. If in fact I wanted to designate someone who's not on Facebook, it's a simple matter of updating my will to indicate what my choice is about what happens to my account when I die. In fact, this is all about respecting your choice and my choice, not turning it over to the estate bar to decide for me. And Madam Chair, I have a lot of my time has been used up. I hope I can get to the key item I came up here to tell you about, is that our providers cannot and will not comply with this law because federal law prohibits us. And your voters and our users say that we should not violate their privacy wishes after they die. We spent money with Zogby to pull over 1,000 registered voters nationally at the end of January. 70%, Madam Chair, said that nobody should access the content of the private messages or photos unless they gave prior consent. That's a 5-to-1 ratio over the 15% who said that the estate executor could make the choice for them. Now, I don't expect polling to drive your lawmaking, but polling shows that this legislation is driven by the estate bar, the estate attorneys. They want to make their jobs easier, but it's not driven by citizens, by you and the choices you make. 70% of them completely disagree with the premise in this bill, and the other 15% who agree that the estate attorney should decide, well, they're going to be disappointed too. Because when their estate attorney tries to get access, the companies are going to say, no, it violates federal law. Nobody gets what they want with this bill, and we have a better way. It's a law we passed unanimously in the state of Virginia at the end of last month. I think the Senator Huckel said that we're not the first state to try it, but 12 states who've tried to run this bill this year have had it fail. Not a single state has passed this bill this year. After Delaware, it's been 0 for 12, and the industry model, which I strongly encourage you to consider as a substitute, is a much better way to go. Thank you.
Thank you very much. There is a question by Senator Abruzzo. I know Senator Sargent has a question, and we are in a little bit of a time constraint because now we have 15 minutes left in committee, so just everyone keep that in mind.
Thank you, Madam Chair. Going back into my line of questioning to the Senator, would this be a more palatable bill if we clarified that this was Florida law, just not any applicable law, which could be anything, which I agree with you, we would have some serious constitutional issues.
Yeah, the Supremacy Clause says nothing Florida says can override what federal law says. So nothing you put in that bill will change that at all.
Okay, thank you. Senator Sargent, have a question?
Thank you, Madam Chair. My questions are way more basic because I'm not an attorney and I can't speak to the legal aspects of although I do find it kind of offensive to say that you will not follow it, even if we end up crafting it in a way that's, we're still a sovereign state and have the ability to craft laws that can affect the people or the citizens of the state of Florida. But given all of that, my question is pretty basic. If I have a power of attorney from somebody right now, can I go on and do everything within their digital accounts with that power of attorney?
If that power of attorney can show that they have the consent of the individual, Senator, they can do everything that individual could do. It's all about consent. And when someone dies without having
I got that. So you're saying the power of attorney needs to say, you have power of attorney to take care of my Facebook account, my Google account, my Gmail account, my Skype account, every account. Oh, and by the way, all my banking.
Senator, I doubt very much they'd have to list each and every account. They're a living person, though, so that someone could slip underneath. Please sign for all your digital accounts and your communications accounts. All that need be there is that which is necessary to satisfy the federal law, the Electronic Communications Privacy Act. And that federal law also provides for an agent for a living individual to have access of certain degrees.
I just find it hard to believe that what is power attorneys today give opportunity for all of my financial things, which I think have much more ramifications to me than my Facebook account. And you're saying it needs to be a different level of consent than what's adequate to take care of my banking.
Madam Chair, it's because when they wrote the law in 1986, they were most concerned about the fact that a custodian who's holding private communications could turn it over without a court warrant, could turn it over to someone who simply asked for it. And they said to protect the privacy of you and me and us individuals, to protect the privacy, custodians may not turn over the contents of the communication. They can turn over the envelope, the date, the time, who sent it, and who received it. So they can certainly turn over a long list of all the banks that have been sending statements to you each month so that the trust attorneys can go obtain that asset for the family. But they cannot disclose the interior contents of communications because they involve other people. And there's where the privacy interest was laid down in law in the federal government in 1986.
Okay, members, let's do this.
For purposes of brevity, Madam Chairman, I'm going to not ask a question. I'm just going to have 2 minutes if I could argue at the end.
Oh, okay, yes, of course. We'll definitely have time for debate.
Thank you, Madam Chair.
Okay, thank you. Let's